Good evening, business law students. It's Monday night. I'm working on this YouTube video. I'm looking at case 8. Here what you have in case 8. This is case 8 in chapter 36. What you have here, the important language here in this case, this language right here, where it said Bradshaw told Reed that the health insurance coverage would begin upon signing some forms and paying the first premium. Well, here what we have is we have a representation done by an agent. This representation that was made is contradicted by the actual language in the policy that says that coverage will begin upon approval. But here the agent said that it would begin upon the signing of the forms and paying the premium. And so what we have now is we have a misrepresentation made by an agent. And the language that's important in your text is this language over here on page 926. Liability for agents' misrepresentations. Several rules apply when a third party sues a principal for misrepresentations made by their agent. A principal is directly liable for misrepresentations made by her agent during authorized transactions if they intended that the agent make those misrepresentations, and that makes perfect sense. A principal may be also directly liable if she negligently allows the agent to make such representations. That is there was a lack of training. Even where a principal is not directly liable, he may be liable for an agent's misrepresentations if the agent had actual or apparent authority to make true representations on the subject. And that's what we have here in this case. Is we have this agent had apparent authority to make these representations, and therefore the principal is going to be bound by those misrepresentations. Now, the real problem for our person that died here, it's kind of ironic that they died after signing the life insurance policy, but before being told that they had been accepted. Just kind of ironic that they died in the interim period. But they, so the insurance company is going to be liable if the family of the person can prove that those representations were actually made. And I think that may be a factual problem here that Bobby Reed has, or Bobby Reed's family has, is how do we prove, in fact, that those misrepresentations were actually done. Anyway, that's case 8 in 36. I'm now going to jump over to chapter 37. Chapter 37 is a purported partnership problem. In other words, or you also hear this textbook uses the language purported partnership. The other phraseology that could be used is partnership by estoppel. In other words, what they're saying is, look, you've held yourselves out as being partners. Because you've held yourselves out as being partners, and we relied upon the fact that you were partners, we are now, in fact, going to treat you as partners. And so on page 943, we see these elements of a purported partnership. A person purports to be or consents to being represented as a partner of another person. A third partner relies upon that representation, and the third party transacts business with the actual or purported partnership. Now, before in the chapter, we've talked about what it takes to be a partnership. A purported partnership does not, in fact, make the partners a partnership, entitling them to shares of profits and shares of assets. The purported partnerships allows outsiders that have dealt with the purported partnership to treat them as partners. And what that means here is we have this boy that was mistreated by this group of physicians. They weren't, in fact, partners, but he was examined by all three doctors. Parents received a bill from the Freed group, so the billing purported that they were partners. All three names were prominently displayed. Dr. Freed examined Michael. They misjudged his serious medical condition on behalf of Michael. They sued all three doctors. Even though she had not committed malpractice herself, was she liable? And the short answer to that is yes, she was, because she was part of a purported partnership, and she allowed herself to be held out as a purported partnership, as a purported partner. Okay, case 8. Case 8 and case 9 are really about who owns partnership assets. It's on page 945 in your text. If you look down in this part of the text, property belongs to the partnership if the property is transferred to the partnership in its name, to any partner acting as a partner by a transfer document that names a partnership, or to any partner by a transfer indicating partner status as a partner, or that a partnership exists. In addition, property acquired with partnership funds is presumed to be partnership assets. So let's look at case 8. We're partners in a retail furniture business. Contribute $150,000 cash. Contribute $100,000. Purchased a delivery truck for the business using $50,000 of partnership funds. Remember the last line in that language saying that if partnership funds are used to acquire it, it's presumed to be a partnership asset. Even though they only listed one partner as the owner of the truck, partnership funds were in fact used to purchase it, and so that pretty much takes care of that case. Case 9, we're partners in construction business. Steve also owned a ranch, which he contributed the partnership, even though Steve was still listed as the owner. Steve learned of a low-interest loan available for the purchase of property from a parent solely to obtain benefits of the low-interest loan. Here, partnership funds weren't used to acquire it. It was the name was never changed on it. There was no intent that it become a partnership asset, and so in case 9, it is in fact not a partnership asset. Case 10. Let me explain to you a little bit about case 10. Remember, we've talked about this idea. That in order for a new partner to be accepted as part of the partnership, all the partners have to consent to this person becoming a new partner. Well, what happens here in case 10 is this new person, is not made a partner, but they have purchased the partnership interest. So what happens in this case is the old partner that sold his interest to the new alleged partner, let's call it alleged partner. When that is sold, but the other partners don't consent, the old partner stays a partner, which means the old partner retains the unlimited liability that they had when they were a full partner. But the rights to the income and the capital, that is the liquidation proceeds, pass now to the new owner. So the owner gets the worst of both worlds. No upside with all downside. All right, folks. That's it. Look forward to seeing you on Friday. Talk to you later. Bye.